Cindy Novak, Downsize Administrator with the Carolyn Stark Real Estate Team. Thank you so much for joining us for our Home Edition event. Today we are so fortunate to be able to share Peter Harbach's program, Estate Planning for the Pandemic. Peter and his colleagues at Hooper Law focus exclusively on elder law. A couple of years ago, my husband Don and I were at a point where we knew we needed to do some planning, but we really weren't sure where to start. We took Peter up on his offer for a consultation. He spent 2 hours with us asking thoughtful questions in just the right order. Then he went to the whiteboard and just clearly mapped out everything that we needed. We were so grateful for the peace of mind he was able to give us. Now, I'm excited for him to share his insights with you. So take it away, Peter.
Hi, I'm attorney Peter Harbach with Hooper Law Office. My law office does nothing but estate planning and elder law, and I've got a number of things to go through with everybody, especially in regards to how you might be prepared through your estate plan for the pandemic, but also, just general tips, even if you are, fortunate enough to not have to experience anything through the pandemic. Accidents, health events throughout your life, anything that might cause your estate plan to kind of kick into effect. And we're going to go through a bunch of different options in planning your estate and a bunch of different pitfalls that I see when I review estates, problems, things like that. So to start off, if you were to fall ill at any time, and that's on top of a lot of people's minds these days, particularly because of the pandemic. It seems to be a lot more random that some people are experiencing severe illness. And so there's certain things that you can get into place immediately to make sure that you are going to be able to get the support that you need during a period of time where you're incapable of making your own decisions and things like that. So every single legal adult, and by legal adult I mean anybody who's over 18 years old, every single legal adult needs 4 basic what we call disability documents in place to make sure that they're appropriately supported if they lose capacity, lose consciousness, things like that. And so those are a power of attorney for finances, a power of attorney for health care, a living will, and a HIPAA authorization. And I'm going to go through each one of those so that you understand what they do, and in addition, give you some tips on things you want to make sure are in your disability documents. So to start off, a power of attorney for finances. It's a legal document where you're saying, hey, if either I become incapacitated, or in some circumstances you might say, or even just immediately, this document is effective and names an agent to step in and handle my financial affairs on my behalf. And one of the things that people need to understand about these documents is that they only provide the powers that are actually written into the document. So I've come across a great number of people who think, oh, well, I have a power of attorney, they can just do anything that they need to. And that's not necessarily true. Because, again, the powers that are written into the document control what they're able to do or not do. And so they're not all written in the same manner. I mean, that's the big takeaway here. These documents are not all uniform. So if you have particular circumstances for yourself about what needs to get managed, or particular concerns like, boy, if I fall ill and I'm not able to recover, and I'm kind of scared of the potentially higher costs of nursing homes and things like that, then you better have terms within your power of attorney for finances that allows your agents to do what we might call strategic planning for long-term care costs. And that can help mitigate those costs and perhaps protect some of your money either for your own use throughout your life, your spouse's use, or potentially if one of your objectives is to be able to provide an inheritance to somebody. So without terms in a power of attorney that actually allows the agent to do that, they don't have the power. And I can't tell you how often I've had people come in where there's been some kind of health event within the family. Let's say, mom slipped and fell and broke her hip, and now she's in a position where she's rehabbing, maybe in the hospital, and everybody recognizes that she's probably not going to be able to go home, and that they need to find a new home for her in like an assisted living facility or a community-based residential facility or a skilled nursing facility. And so they start looking into the costs, and some families are very shocked that an assisted living facility can very easily be $4,000, $5,000, $6,000 a month, and a skilled nursing facility is often close to double that, $8,000 to $10,000 a month. And so they start scrambling and thinking, boy, is there anything that we're going to be able to do to try and protect some of the funds so that mom's not just completely broke for the rest of her life, because maybe she can afford to do this for a year or 2 years, but then all of the money's going to be gone. So a lot of times one of the children starts looking into these things, and through the internet or some kind of referral or source, they land on my front door and say, hey, this is my problem. Is there anything that we're going to be able to do? And one of the first things that I want to see as the planner is, can I please see the power of attorney for finances? Because if mom doesn't have capacity to sign new things, because maybe she's really out of it or incapacitated, then the power of attorney for finances has become my toolbox. That's the only powers that the family has to handle these financial things. And so I need to know that they're able to plan around these long-term care expenses through that power of attorney, or else it's kind of pointless to talk to me, because even if I could come up with a wonderful plan, nobody has the ability to implement it. And so that's sort of the first step, is if you're concerned about, if you lose capacity, if you become sick, God forbid you get the coronavirus and it's, you're not an asymptomatic person and you have a long, period of illness or disability, you need to make sure that you have somebody that you trust in a place with the right powers that they need in order to handle your affairs for you. A lot of people think that, hey, if I'm married, my spouse can just do it, or I trust my son, so he can just be the agent. Well, you actually have to put it in writing, in a legal power of attorney for finances, because these people don't just naturally have the ability to do this sort of stuff. They can't just step in. If you don't have that kind of thing in place, the family is required to petition the court for something called guardianship. And the court decides what powers to provide to a guardian. And the guardian may be your spouse or your child, but it's up to the court to provide those powers, and they very likely would not provide powers that are going to be in any way helpful for long-term care expenses. And so right when you need the most flexibility and control over the finances, because you're in the biggest kind of financial crunch of your life, that's when your hands might be the most tied, because you can only do things with court approval. So when you're choosing an agent for finances, distance isn't a real big deal these days. You can have a good agent for finances who's across the country because online banking, fax, email, just long-distance phone calls, it's not hard for them necessarily to do the job in managing your finances. So generally the criteria that I talk to my clients about in picking a person like this is got to be somebody who's trustworthy. And that should be a no-brainer, because this person's in charge of all of your money during your lifetime. You certainly aren't going to throw the fox in the hen house. You want to have somebody that you absolutely trust who's going to do their best to do a good job for you. And the other thing that you need is somebody who can get things done in a fairly timely manner. Because if you pick a very trustworthy person, but they're always kind of slow in getting things done, that might have an adverse impact on you and your own finances. I mean, sometimes if they can recognize that, boy, this guy has to get done quickly for it to be useful, that's the kind of person that you want in there, not, oh, I never seem to have the time, I never seem to have the time. And you'd know the personalities if you're looking at your kids, which one of them's always late in filing their own taxes and which one of them's kind of Johnny on the spot. So you can absolutely use loved ones or friends to be your agent. You don't need some kind of separate professional, assuming that you have somebody who meets these two criteria. If you do not, well, there are professionals who will act as fiduciaries on your behalf. Companies that will step in, manage your finances in an event of disability, and help you out. So it's just critical to get one of these powers of attorney for finances in place because, again, sudden illness, health event, accident, there is nobody that can just naturally step in and do it for you. The second document is a power of attorney for healthcare. And a power of attorney for healthcare is very similar to a power of attorney for finances. They're just managing healthcare matters as opposed to financial matters. So again, it's an agent that you trust. The difference really between the power of attorney for finances and healthcare, other than the exact role that they're playing, is when you're selecting somebody, I'd strongly recommend that you have somebody that is local, or at least generally can get to you relatively quickly, assuming that you have somebody who is trustworthy and conscientious. Because a power of attorney for healthcare, it's a little harder to do that job at a great distance. Just even being able to see you, and if you're in a care facility, kind of pop in and monitor how things are going and understand what the situation is, that's going to be a big deal in making sure that you get the best care possible. It's hard to monitor that kind of stuff by phone calls at a great distance. So, if the only person that you trust is somebody that is at a great distance, well, so be it. I mean, that's the most important criteria for any of this, and so maybe you would pick that person who's at a distance. But if you do have somebody that you trust that's local, that generally is much more preferable because they have a greater opportunity for success in that role if they're able to get to you, see how you're doing, monitor your care, interact directly with the doctors, nursing staff, whoever it might be that's involved in your ongoing care, asking questions, and then just really seeing how you're doing. But the agent, their job is to essentially be your healthcare advocate. And their job is not to make all the decisions themselves based on their own criteria. They're supposed to use something called substituted judgment. And that basically means stepping into your mindset and understanding what you would have wanted, and then trying to make the decisions based on that criteria. So not necessarily their own beliefs in healthcare, they're trying to act and just express what you would have wanted. So for them to be successful in doing that, they really need to understand how you feel about your healthcare, what you do or don't want, the type of person that you are. And this is where, family members are kind of going to naturally know some of these things. Are you very independent? Are you very social? That can also help them pick in terms of the criteria for transitioning into a long-term care facility. They really kind of know you, and they know, boy, you'd love to be in a place that would have a lot of activities because you're a very sociable person, or maybe you're more private and aren't as interested in lots of people and activities, and so maybe you want them, a little bit more of an isolated type of facility. Those types of things, a lot of family members are just going to sort of innately understand. But some other things, it's important that you lay out the criteria in your healthcare power of attorney document, but in addition, have conversations with these people. You don't have to keep all of this estate planning a secret. And I can't tell you how many, especially the older generation, the people who are in their 80s and 90s now, which might be some of you that I'm talking to right now, try and keep all of the sort of healthcare and financial things really private. But you need to understand that in order for people to be successful in helping you and stepping into this role, they need to understand, really what you want, and also on the financial end, what it is that you have. I wouldn't start a company and try and transition that company by saying, okay, I quit. Hey, you over there who has zero experience or understanding of my company, take over, you're the president. Well, your own finances and healthcare decisions are very similar to that, in that if these people don't have any understanding of, what you own, who you have your insurance through, what your investments are, what your bills are, and then on the healthcare side, what you do or don't want, your preferences for both surroundings and whether or not you'd want life support in various circumstances. They can't just step in and do a perfect job. So again, setting people up for success in these two roles is critical for the success because of you. I mean, this has a huge impact on your life. This is your finances getting managed. It's your healthcare decisions getting made. You got to take some effort into setting these people up for success. So conversations are going to be king, and a little organization goes a long way. Making sure that they have access to your bank account records and your life insurance policies and your investments. And if you have an investment advisor, them knowing who that person is, knowing where you're keeping your estate planning documents and you having those organized. Because without this, remember, something unforeseen happens to you, because I don't know about you, but I don't have my own disability calendared on, hey, October 3rd of 2053, I'm going to get in a car accident. I don't know that. So it's very often a sudden or unexpected thing. And so people need to be able to step in, and we don't want them having to break into the house and root through everything, going on sort of a hide-and-go-seek mission of, I found this statement, so I guess maybe mom's got a Community First account, and there's a receipt for some life insurance. They paid a premium here. All right, well, we'll keep an eye on that. We don't know if that's still in effect because this check that they wrote out was from 2017. It's a nightmare. So, part of estate planning is trying to make this job easier on the people who are kind enough to be stepping in and helping you. So, again, a little conversation and organization goes a long way. The third document, the living will, is also called an advance directive to physicians. And this one is basically letting people know what are your desires when it comes to these end-of-life decisions. Would you want to be maintained indefinitely on life support if you were in a coma or had some kind of terminal illness? Or would you authorize the removal of life support? Do you want pain medication? And if you can't recover, would it be okay if that pain medication was substantial and may even hasten your death? Or is that not acceptable? There's a lot of decisions around these things that you need to make sure that the family understands, and you do it in writing in something called a living will so that it's clear. You got a clear legal document that lays out your wishes, but then also your agent can not just draw on that to make decisions, but also they can show that to other people who might care about you, who might question whether or not the agent is making the right decision. Because you can't possibly talk to everybody you've ever met about what your end-of-life decisions are, but if you memorialize it, and you maybe have talked to the kids and your spouse, well then if your sister at the time you were in that car accident or had coronavirus or whatever it might be, your sister steps in and says, hey husband, meaning your husband, I don't know that my sister would have wanted the removal of life support here. I'm questioning whether or not you're making the right decision. Well, if he's got it in writing from you that says, hey, this is absolutely what I would or wouldn't want, well then that kind of clears the air on that and makes sure that the sister really understands that, yeah, he's not making some separate arbitrary decision on his own. He's just communicating to the doctors what you would have wanted. And it's very clear because you took the effort to memorialize it all correctly. Then the last document in what we are calling these disability documents is a HIPAA authorization or HIPAA waiver. And what that basically does is there's this giant federal law that essentially says any legal adult, and legal adult is somebody over 18, any legal adult, their health care information is protected under this federal law. So, doctors can't be out just gossiping about what kind of health care they're providing to you or anything like that, which the concept there is a really good idea. The frustration sets in because this also keeps loved ones from being able to receive any health care information about you. And so if, for instance, you got in a car accident and you're whisked off to the hospital and you're not conscious to sign consent forms, well then, if your daughter comes in and says, "How's mom doing?" the daughter's unlikely to be able to get any information because of this federal law, because the law does not assume that families get along or anything like that. So it's important that you kind of create an in-circle of people who can find out, well, how are you doing? So that kind of thing is particularly important these days, again, with the pandemic, because some people, unfortunately, who are catching the virus are declining very rapidly and might not be capable, if they are going to the hospital, of understanding and signing any kind of forms. So this means that the family, who is obviously very concerned about the circumstances, are potentially going to be prohibited from even finding out what's going on in terms of the person's status. Are they getting better or worse? What kind of treatments are being, administered? I can't fathom anything more frustrating or scary than something happening to one of my loved ones and not even being able to find out what's going on. And so, unfortunately, that's kind of the unintended effect of this federal law. Again, the intent is good. We don't want our health information to just be, public record or just can be given out without consequence by whomever. But at the same time, we want to make sure that the people who we care about and care about us get access to information in a time of, crisis or emergency. And so how you do that, again, is you have them all listed out in a HIPAA waiver. A lot of people will say, oh, yeah, well, I signed one of those at my doctor's office, so I got that squared away. Unfortunately, that's very likely written in such a way that it only applies to that particular doctor's office, and not necessarily if you got whisked off to some other hospital or some other medical institution. Those waivers are not necessarily transferable. So it's important that you have a general waiver in place that essentially says, well, wherever I'm getting my health care, whether it's my regular doctor's office or in some hospital in Las Vegas when I was out on vacation and got in an accident, wherever it might be, these are the people I want to make sure get this information, because otherwise they're going to be, unbelievably scared and frustrated. So with those 4 basic documents, that's where you've set your family up for success in supporting you, where they can make healthcare decisions if you're unable. They can make financial decisions if you're unable. They have access to health information and clear direction about what you would or wouldn't want, especially in end-of-life decisions. So if you get those things in place, then the family doesn't have to go through guardianship court, and they likely have the ability to handle very significant healthcare bills from things like long-term care, because you've provided a support system that says, yes, they're able to do strategic planning around my healthcare costs to make sure that by the time I recover, I'm not flat broke. So those are the basics on dealing with the finances, the healthcare, and disability concerns. The next group of topics here is going to be, what if you were to suddenly pass away? And making sure that your estate plan is appropriate for your circumstances and properly takes care of the people that you care about or the organizations that are close to your heart, or whatever it might, whatever your priorities might be. So if you pass away, this is where your estate plan kind of kicks into gear. and there's multiple different tools when it comes to estate planning. There's not one correct solution or anything like that. It all just completely depends on what your priorities are. So for instance, a lot of people do estate planning through a will. And almost everybody knows what a will is. It's your sort of wishes about where your property is going to go, or if you have young ones, who's going to be the guardian of those young ones. What people don't understand is how in the heck a will actually works. And this is where people get tripped up on their own estate plans all the time. You need to realize that your will is a set of instructions to the probate court. That's what it actually is. So a lot of people think, oh, I wrote a will, so that means my family's not going to be in the court system. But that's not at all true. Because again, a will is actually the instructions that you're given to the probate judge about, well, this is how I want different things to go to different people. How this gets screwed up a lot is people think that, oh, I wrote it in my will, so that's what happens. The problem with that thinking is a lot of people simultaneously have assets that, oh, I don't want to have this go through probate, so I put a beneficiary designation on it. And a beneficiary designation is essentially kind of a company contract that you say, hey, custodian of my money, or hey, life insurance company, if I pass away, I want this stuff to go, say, 50% to my son and 50% to my daughter. And so that's where I want that stuff to go. What you need to understand about that is those company contracts pay out directly to those people, which means if you put any terms in your will for those people, those terms don't end up applying. So that can be a really big problem if, for instance, say your son and daughter are 12 years old and 6 years old. In your will, if you were talking to an attorney and drafting that, the attorney probably said, boy, we need to take into account the circumstances of your young son and daughter, and they can't own money or manage money themselves at 12 and 6 years old, so we got to put terms in your will to make sure that they're taken care of. And so maybe you're naming somebody else to be in charge of the money until such an age that you think that they can handle it themselves. And a lot of people, 18 is a legal adult, but that's never a good idea to just hand the money to an 18-year-old. They're never mature enough or have enough life experience or know enough about investments to just suddenly be managing tens or, God forbid, hundreds of thousands or millions of dollars. So that's where you can do really nice stuff in your will that says, boy, I want to make sure that my brother, their uncle, is in charge of the money until maybe they're in their 20s. And he can use it on spending on their college tuition, new shoes, whatever they need, just like I would have if I were still alive. But they don't get to just demand a bunch of money for spring break or anything like that. So again, you might have done all of this really nice planning in your will, but then you might have ruined it by putting a beneficiary designation right to those kids so that the money never goes through the probate procedure to get into the planning of your will. And so I see that happen all the time. Because again, people's mentality tends to be, oh, I wrote it in my will, so that's what happens. But not understanding that that's not necessarily what happens. How you pass assets, the legal mechanic of you passing assets, has just as much control over the success of your estate plan as the terms of your will or trust. And I'll get to trusts in just a moment. But the big takeaway for this is if you have an estate plan, make sure you're not essentially destroying it by not having your assets properly coordinated with your estate plan. Again, people will do wills, do great planning in wills, and then be told by somebody, oh, just put a beneficiary designation on there, then it avoids probate, that'll be so much easier. Okay, that also means it avoids the terms of your will. So if your priority is to avoid probate, then a will is not the right tool for you to use because the wills are instructions to the probate court. So It's like buying a record player, but your intention is to play nothing but digital music. Your record player's not doing anything then. So it's not because the record player's a bad tool. Some people love record players, but it's not serving the purpose that you intend for your estate. So if you want to avoid probate, you don't have any point in creating a bunch of planning through a will because you're not using the thing. Trusts, on the other hand, those are essentially legal agreements about how properties to get managed during your lifetime, who's in charge of it if you become disabled, for instance, and then where it goes when you pass away. They became very popular back in about the 1990s because there was a way to do estate tax planning, which could save substantial amounts of money back when estate taxes hit a large group of people. The exemption amounts were very minimal, about $650,000 per person, and that included your life insurance, your house, all of your savings. So a lot of people had very strong reasons to not have to pay like a 55% tax, which used to be the old estate tax rate, by doing revocable trusts primarily. Well, everybody has a really big coupon now from having to pay estate taxes. It's about $11.5 million. So most people are not really doing revocable trusts for estate tax purposes, but instead, they're often using them as a tool to not have to go through probate, but as a way to also have planning around the assets. The way you can plan in a will, but have to use the probate, you can plan in a trust and avoid a probate. So trusts are not a type of investment or anything like that. A trust is, again, just a legal agreement, and you still have all of your same investments. There's no change there on what you own or how you're managing your own money if you're using a revocable trust. You're just doing it through a trust as opposed to your own name. So again, those became popular because people want to avoid probate, but then do this type of planning for the family, like, hey, I want to pass assets on to my son and daughter, but I also want to make sure that we're out of probate and that all of these different terms apply to them, because maybe they're underage and you want to make sure that you support them in all the right ways, but you do not want them to just have unfettered access to these funds, so you create the terms that you think are going to be best for them. The takeaway for this is understand the differences between wills and trusts. Neither one of them is right or wrong. It just depends on what your priorities are. If your priority is avoiding probate, a will's not the right solution. Maybe a trust is the right solution. Maybe beneficiary designations are appropriate for your circumstances. It depends on what you're trying to accomplish for the family. Remember that this affects every penny you have at the time of your passing. So it's not something to take lightly or to just kind of gloss over, or, I mean, certainly not the thing where I'm looking for the cheapy, bargain barrel solution, because remember, this is every penny you've got and what's going to happen to it and how you're going to support the people you care about the most. Also, take into account the individual circumstances of your beneficiaries. Are they young? Are they ill? Do they have a diagnosis that could eventually be debilitating? Are they good with finances? Are they terrible with finances? Do they have substance abuse issues, gambling problems, creditor issues? Are they very successful, but maybe they own a business of their own, and maybe the success of that business can be dictated a little bit by the economy bouncing up and down, where if we continue in sort of a recession phase here or have another 2007, 2008 era, are they potentially going to be struggling a lot because they've got personal guarantees out on contracts through their business that are maybe going to not just hurt the business, but then also maybe really hurt them personally, financially. Because there's ways to plan when you're passing an inheritance onto for all of these different things that I was just describing. There's ways to try and protect the beneficiaries from both themselves and maybe their own bad decision making or bad judgment, but then from others, bad circumstances that can happen to a very responsible business owner or a professional. Doctors, lawyers, those people are inevitably a little bit more sensitive or concerned about lawsuits because the nature of their profession kind of opens them up to liability a lot more. And so there are a lot of things that you can do through your estate plan, through either a will or a trust. But the key is to think through the individual circumstances of your different beneficiaries and who you care about, and then make the best decisions with the help of an attorney who can kind of guide you through. Oh, okay, if your son is not great with money, these are your different options through your will or trust to make sure that the money is supporting him in such a way that you would have approved of that, and isn't just squandered on a $100,000 car and maybe a few harebrained ideas. Or your daughter, who is a successful business owner, this is how we can make sure that the money that passes on to her at whatever time that might be is maybe protected from her business liabilities. So lots of different options through an estate plan, but it takes a little effort and thought on the front end while you still have capacity in order to achieve these things and make things as smooth as possible. Because again, especially if there is a sudden illness or death, this stuff has to spring into action and work correctly. And so being proactive in this planning goes a long way to make sure that it's going to be successful and that these people have the easiest job in administering your estate with the smallest amount of potential expense in doing so, but also clear direction so that the money is used in the best way possible. Think of this as kind of your last opportunity to get a return on your investment of your life savings. Setting these people up for success where the money isn't just taken can be a huge gift to them. So a lot of things to consider, and making sure that these clear directions also are capable of providing kind of harmony amongst the family. Because if you're unclear or there's unmet expectations, that's where we get this litigation, families fighting after the fact. And it's an emotional time. I mean, especially if this is an unforeseen passing that happens very suddenly, grief can come out in kind of weird ways. And sometimes they're redirecting it to other members of the family. And if the estate plan's not clear, they might be keying in on that as sort of the outlet. So having these clear directions can help quite a bit in making sure that the money's getting a good return on your investment and passing it on to these people, and good harmony amongst the group. So next, we're going to talk about, well, what happens if you, become ill or have an accident, disability where you're going to require care over a substantial period of time. And, unfortunately, one of the parts of this pandemic that don't catch as much news is not everybody necessarily is either fully recovering or passing away from the coronavirus. Doctors are finding more and more that there can be kind of long-term disabling effects of the virus. And so this could increase the possibility of needing long-term care maybe earlier in life than would have been anticipated. And so the topic here is, well, what if you are facing long-term care expenses? Are there any options? And the answer is almost always yes. A lot of people assume, because they sort of have a general notion of, oh yeah, there's some kind of look back period where if I go into a nursing home, I had to have done planning, enough years in advance, or else I don't have any options. And the look back period presently is 5 years. A lot of people, for some reason, think it's 7 and ask me, hey, I thought it was turning into 7. It's not. That doesn't mean it couldn't in the future, but there's no current law that says at any point it's going to be 7-year look back. But that is the look back period when you're trying to do pre-planning, where you're saying, hey, in advance of me ever needing care, I want to make sure that I have certain assets protected, maybe the family farm or whatever the big priority might be. But that does not mean that you have no options if you do not have 5 years. So even if somebody is already in a nursing home today, while you're listening to this, and you're concerned about their care costs, they have options. Now, if they have capacity, meaning they're capable of signing things and making decisions on their own, they've got tons of options. They have an ability to be very strategic and can actually preserve a significant amount to make sure that they have a good lifestyle. If they do not have capacity, this is where I'm circling back to that conversation I was having earlier about the power of attorney is now our toolbox. If they have a good power of attorney document that provides lots of powers to the agent in order to do things that can be beneficial in preserving assets from long-term care expenses, well, then they have all the options. They have lots that can be done. The only time where you're pretty limited in your options, if somebody does not have any capacity and doesn't have any kind of an estate plan in place whatsoever, where they're providing any authority for anybody to help them. That's where the ability to do anything is going to be extremely limited. And so what we are always asking about in these conversations when somebody's already going to be facing care either imminently or they're already in there is, what do you prefer? I mean, are we trying to stretch your money out for as long as possible to make sure that you have the best potential quality of life? And there's different things that can be used in terms of loan agreements, caregiver agreements, first-party pooled special needs trusts. There's a lot of tools that potentially can be helpful that can make sure that, okay, some of this money is capable of being held on to while you get assistance in paying for care. Primarily, a lot of people will be using Medicaid as the assistance in paying for care. Veterans or the surviving spouses of veterans can also apply for something that's called the Improved Pension Program, which provides an amount of money that can help offset medical expenses either at home in an assisted living facility or a skilled nursing facility. And that can be, $26,000, $27,000 a year tax-free. And that can be a great program. There's financial eligibility requirements for that one, just like there is for Medicaid. But it can be a source of payment to help stretch out money. So again, it depends on, are we trying to make sure you've got a good quality of life? Is the biggest concern, boy, if we use it all up on me, how's my spouse going to afford to stay home? Or how are they going to afford good care later in their life? Because if I gobble it all up because I need care right now, and I get Cadillac care for the rest of my life, well then, what options is my spouse going to have in order to get their best care? So that might be the big priority. Or again, it might be, hey, this farm has been in my family for 4 generations, and I can't fathom losing it to long-term care expenses. I want to make sure it passes on through my family to a 5th generation. There are a lot of different types of priorities that I hear from people, and that actually dictates how the planning might go. The only way you really end up getting yourself in trouble is by trying to do this sort of stuff on your own. I've had so many people who they have some loved one who reads something on the internet and they think they've got a smart idea and then they start doing it. For instance, a lot of people ask me, well, what's that amount that you can give people every year where you don't have to disclose anything about it? And what they tend to be referring to is the IRS's gift tax exclusion amount. And what that means is it's excluded from having to tell the IRS about the fact that you made a gift. And that number, by the way, is $15,000. All that means is you don't have to fill out a Form 709 to report a gift to the IRS if you made gifts that were all under $15,000 or a married couple, $30,000 to any individual. So you could give, if you're a married couple, you could give $30,000 to every one of your kids every single year. You're never going to report anything to the IRS. And that number is indexed for inflation, so at some point it'll become $16,000 and then $17,000, et cetera. However, that amount has nothing to do with keeping it safe from nursing home expenses. And this is where that whole 5-year rule comes in that we were talking about, that look-back period. If you give away $15,000 to each one of your kids every year, and say you've got 3 kids, so that's $45,000, well, if you go into the nursing home a couple of years later, and you've given away $45,000 each of the last 2 years, that isn't a safe haven that made it protected from nursing home costs. All that rule was is I don't have to tell the IRS about it. Because when you put in an application saying, boy, I'm facing $100,000 a year nursing home cost, can I please get some assistance? They can go through your bank records and everything else and determine and ask you, and you can't lie, what have you done for the last 5 years? Have you given any amount of money away to anybody where you didn't get fair market value back for it? And if you say, you'd have to tell them, yeah, I gave $45,000 each year to my kids. And so their response is going to be, okay, you've now got a $90,000 penalty period, which means once you're financially eligible for our program, meaning down to low enough money, then we're going to start our penalty. And that penalty of that amount is going to be roughly about 11 months. So good luck paying for care for the next 11 months or so, because you're mostly out of money and we're not going to help you at all. And that's where people can end up getting kicked out of facilities. So don't try and outsmart this stuff and go, oh, well, my son said I can just start making these gifts. That'll be a good idea for me. Because it isn't. It has to be part of an overall strategic plan, because there are so many rules that I could be sitting here still talking until October, and it's August right now, by the way, and I still wouldn't have to repeat myself. I'd have enough to say about how this planning actually works. So if it's a concern where you're trying to do emergency planning, make sure you seek out advice from somebody who really knows what they're doing and does a ton of this kind of stuff. And you can walk through all the different priorities that you have, and that person should be able to give you all of the different options that fit those priorities. There's no magic bullet, one-size-fits-all kind of planning when it comes to trying to preserve some amount of assets from long-term care expenses. So again, the individual circumstances of the client, the composition of their assets, the priorities of them and the family, that all has to get taken into account in determining what's going to be the best course of action to make sure that it's not all completely exhausted at an incredibly rapid rate. Last topic is a couple of miscellaneous things regarding a big change in the law called the Secure Act, but then a little something about the Coronavirus Act, or the CARES Act, that affects a lot of people. So the Secure Act, you want to pay a lot of attention to if you have IRA money or 401k money, any kind of retirement accounts of your own, because number one, the age of required minimum distributions changed. So new to 2020, if you're under 72 years old, you do not have to take funds out of an IRA or a 401k as a required minimum distribution. The age used to be 70 and a half, but the law put it up to 72. The other really big change is that now, if somebody inherits any of these retirement accounts from you, it used to be that they potentially had the rest of their life expectancy, and their life expectancy is based on how old they are on an actuarial chart. They used to have their entire life expectancy to take out of these retirement accounts, and that matters because this is pre-tax money. And so however much you have to take out in a lump is the amount you're taxed on in that tax year. And so it used to be that you had to take out little tiny amounts for most people because they might have a 40-year life expectancy, for instance. So the first year you only had to take out about 1/40th of it. Well, now, with only very limited circumstances for a group of people referred to as eligible designated beneficiaries, which is generally like a spouse, a child with a disability, a person who's no more than 10 years younger than you, or a child that is a minor. Except for those people, anybody else, so like an adult child or your grandkids, most other people you might be considering leaving retirement funds to have no greater than 10 years to take out of that retirement account and be taxed on it. And so that's a really big change, because if a lot of what you've invested in is retirement accounts, part of the reason you probably did that was to reduce the amount of taxation that might hit the account. And so you might have built up quite a bit of retirement nest egg in these pre-tax accounts. Well, if you maybe have just one child and they're working hard and are pretty successful themselves, and your whole retirement account is going to go to that child, well, they have no more than 10 years to take all of the money out, and they're taxed on top of their ordinary income on those funds. So say you built up $1 million nest egg in these retirement accounts, and you pass away, and it goes down to this child who's, again, working real hard themselves and is successful. They're going to have at least about $100,000 a year in extra money that they're getting taxed on. They're not required to take money out every single year. It just all has to come out in 10 years. Problem is, if you just wait the whole 10 years and take out the $1 million in 1 year, well, then you're taxed on your own income plus an extra $1 million. So then you're really paying through the nose. But it's a really big change in the law. And so if you have a will or a trust-based plan and your IRA is intended to be governed by that plan, and you haven't done your estate plan over the last year, if it's several years old, you almost certainly want to look back at your existing estate plan and have a conversation with an estate planning attorney about, how does the Secure Act impact me and my documents? Are there any updates that are necessary? Because if an IRA is a substantial part of your overall portfolio, you don't want to leave the tax planning to chance and just hope it works out. You want to address that stuff head on, because I've never had anybody say, when I die, I want to give Uncle Sam more than than I possibly need to. Nobody's ever told me that. And so addressing that stuff through your estate plan, again, proactively, because you're the only person who can do it and take care of this, can make sure that you're minimizing the amount of taxation that gets passed on to the beneficiaries. And then with the CARES Act, everybody should know that in 2020, you do not have a required minimum distribution. And so even if you're 95 years old, this year you do not have to take a required minimum distribution because of the whole coronavirus. So It doesn't mean that financially your best choice is to not take anything out. You're going to want to talk to your financial advisor if you have one, and your CPA, and decide, okay, how much money do I have in these retirement accounts, and what is my income this year? Does it make sense for me to take a withdrawal even if I don't have to, or do a Roth conversion, which means paying the tax on it but leaving it in a retirement account? These are conversations you're going to want to have with the professionals that you surround yourself with. And one last thing about professionals, if you don't have a financial planner, especially if you're a married couple and one of you really handles a lot of the finances and the other one doesn't get very involved, you probably want to contact a financial advisor just to have somebody on deck so that that spouse who isn't as involved in the finances and might be overwhelmed by it has somebody that you've both vetted during your joint lifetimes that they can turn to if it's the spouse who handles all the finances that dies first. Set that remaining spouse up for some success and the support that they probably need. But then also, you can get invaluable information, like what I was just talking about with the CARES Act and taking required minimum distributions or holding off. And, it affects your estate plan in a huge way. Is what is the likely composition of your assets at the time of your passing? So take all of this stuff into account. And if you think, boy, I saw some good information there, it's not enough to just take in information. It was only valuable to you if you did something with that information. So fix your own estate plan. Take action to deal with long-term care expenses. Seek out a financial advisor. If you need an estate planning or elder law attorney and you don't regularly work with one, we're happy to meet with you. Take some action based on the effort you had. You spent a lot of time with me today in watching this, so now go put this information to good use. So I appreciate everybody's time. Please stay safe, enjoy your summer, and if anybody needs to reach out, please feel free to contact us. We're always happy to sit down and talk to people about their own individual circumstances.
Hi, I'm Carolyn Stark with the Carolyn Stark Real Estate Team. Thank you for joining us today, and I want to thank Peter for giving us a great presentation. I hope you all have a good day.